Hi everyone, welcome. So today I will be talking all about how to file for your children to get a green card. Okay? That's what we're going to be talking about. I know how important this is. So we're going to be breaking it down step by step and explaining what kind of documents you need, what the time frame is, and the little things you can do to make the process a lot easier for yourself. Okay, so that's what we'll be talking about today. If you don't know me, I am a U.S. immigration attorney. I am Lilian Chukwurah. I'm the owner and attorney at Lily Legal. We help our clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. So, if you are interested in U.S. immigration law, getting green card, getting citizenship, make sure you subscribe to this page. And if you would like to speak with me personally to basically figure out what options are available for you and your family, go ahead and schedule a strategy session by going to my website, lilylegal.com, or by calling my office at 508-443-1788. All right, enough of that. Let's jump in. So, first thing first, right? So, you are either a US citizen or a permanent resident, and you're looking to file for your children. Now, let's start with a US citizen. If your children are in the US, let's break it down, right? A US citizen can file for all their children. It doesn't matter how old they are, it doesn't matter if they're married, none of that. What does matter is how long it's going to take. So, in all of this, I'm going to talk about filing for children that are under 21 and unmarried, and then filing for children that are over 21 and unmarried. And then the final category is children that are married. Okay. So for a US citizen that wants to file for a child that's under 21 and unmarried, the question is, where is the child, right? If the child is in the US and they came to the US with a visa, or they came to the US and were paroled into the US, basically given permission to come into the US, then guess what? You can just file for them to get a green card in the US. If the child is outside of the US, then the process is a little different, right? You would have to file an I-130 with USCIS, wait for that to be approved, and then they will complete the embassy stage, go to an interview at the embassy, and then come in with a visa. Once they land in the US, though, they will automatically be permanent residents of the US. All right. So that's the process for children under 21. The only waiting time is really how long it takes USCIS to process the I-130, how long it takes the embassy to schedule an interview, right? There's no additional waiting time beyond just however long it takes for the application to be processed. Okay. Now, if the children are over 21, but unmarried, right? They're over 21, but they're not married. As of today, that I'm doing this video, the process is you file an I-130, you wait for that to be approved, and then you wait for a visa to become available. So for children that are over 21 of US citizens, there's no visa immediately available to them. So because of that, you have to wait for the visa to become available. Right now, it's taking about 7 to 8 years for a visa to become available. So that's 7 to 8 years from the time that you filed the I-130, right? 7 to 8 years from the time you filed the I-130 for a visa to become available. Once that visa becomes available, then you can start the embassy stage. Remember, I said for children of US citizens that are under 21 and outside of the US, they have to They can start the embassy stage as soon as the I-130 is approved. But for children that are over 21 and are married, they cannot start the embassy stage, even if the I-130 is approved, until there's a visa available. But once there's a visa available, you can start the embassy stage, go to your interview. Once you're approved, you come into the US, you would be a permanent resident. Now, if your children are married, right, it doesn't matter how old they are. All that matters is that they are married. So if you have an 18-year-old child that is married, they are not considered under 21, right? The rules for under 21 does not apply to them. Once they get married, they are now in a separate category. So for children that are married of a US citizen, those children, it's basically the same process as the ones that are over 21 and unmarried, except the waiting time for a visa to become available is closer to 13 years. Okay, so don't wait. I guess it's um the thing to take away here is don't wait. You can go ahead and file once you're a US citizen and just wait for the time to tick away. Okay, and just know once they're over 21, they are now in a preference category. And what that means is if they have children outside of the US and you file for them, they get their visa. Guess what? They can also get a visa for their child that is also outside of the US. Okay. And that's even if they have the child after you file the I-130. So it's not just your child that you're filing for. If they are married, their spouse can come with them. Their children can also be included in that visa stage. All right. So there is a benefit to going ahead and still filing, even though they're over 21, even though they're married. All right. So that is the basics of that. Now, if you are a permanent resident, you can only file for children that are unmarried. So it doesn't matter if they're over 21 or under 21. As long as they are unmarried, you can file for them. The second they get married, you can no longer file for them. So let's say you start the application. And this is where people really don't understand. So let me break it down. So if you are a permanent resident and you file for your child, and while you're waiting for that application to be processed, for a visa to become available, your child decides that they're going to get married, right? They get married while you are still a permanent resident. Guess what? That application goes out the window. That application is over because a permanent resident cannot file for a married child. Now, let's say you are a permanent resident when you started the process. Your child was already over 21 before you started the I-130 process, and you're waiting for the 7 years to tick by. And while it was ticking, you decided to become a citizen. After you become a citizen, your child decides to get married. In that situation, the application is still safe. The only thing is you have to inform US immigration that your child is married so that they can change her category from the child over 21 and unmarried to a child over 21 and married. Okay, so that the application process can continue. But now it's because you're a US citizen and your child got married afterwards. That also means that the waiting time for a visa to become available is going to be longer. So those are the children that you can file for and how that works. Now let's talk about the definition of a child, because sometimes we don't think about that. Right? What is the definition of a child in immigration law? Right? If you are the biological parents of the child, the adoptive parents, or the step parent, you can file for the child. Now, let's start with the biological parents. Basically, you have to prove that they are your child. Name on the birth certificate. Sometimes USCIS or the embassy may require a DNA test, right, to prove that it's actually your child. This is typically for fathers, not mothers. So for mothers, they usually just go with the birth certificate, right? But for fathers, they may require a DNA test. So don't be surprised when you apply for your child and they ask for a DNA test. It is normal, okay? It is completely normal. So that's how a biological child, filing for them and proving that relationship. For an adopted child, there's a whole process, right? You have to prove that you went through the right adoption procedure for the country that the child lives in. USCIS will only let you apply for a child if you meet the adoption requirements. And that is a big deal. And I will be doing a follow-up video just on adoption and filing for a child after adoption. Okay, because there's so much there. It depends on the age of the child, your status as a U.S. citizen or permanent resident, and the country the child is in, if they are a part of the Hague Convention. Let me just say this, if you want to adopt a child that is part of the Hague Convention, please do not go ahead and just go to the country and do an adoption. Please do not do it, because if you do that, that means you didn't follow the actual rules for the Hague Convention. And USCIS has specific rules and applications that you have to file if you want to adopt a child that is part of the Hague Convention. So I will be doing a whole other video breaking those down, because it's just a lot and it's kind of out of scope for this. So if you have an adopted child and you went through the right procedure, you can file for them to come to the US, right? The process may be a little different, but you can file for them to come to the US and get their green card. All right. The last child definition is stepchildren. Okay. For stepchildren, you have to have been married to the child's biological parent before the child turned 18 for it to count. So let's say you got married today and your spouse has 3 children, right? One is 12, one is 17 and a half, and the other one is 20, right? In that situation, only 2 of them count as stepchildren for immigration purposes, right? So even though in your day-to-day life, that is your stepchildren, right? All 3 of them are considered your stepchildren. However, for immigration purposes, only the 2 that were under 18 at the time you married their parents counts as a stepchild. And if they count as a stepchild, then you can file for them just as you would a biological child. All right. So you can file for them, do the I-130 adjustment of status in the US if they came in with a visa, right? If they're outside of the US, you would do the I-130 and then wait for that to be approved, go through the embassy stage. That, of course, again, the only processing time, the only waiting time is the processing time. How long does it take USCIS to complete the first part? How long does it take the embassy to schedule the interview? Right? You're not waiting for a visa to become available, because if you are a US citizen and they are your stepchildren and they are under 21, they are considered immediate relatives and you only have to wait for the processing time, right? A visa is immediately available to children under 21 and unmarried of US citizens. Now, let's say you have stepchildren that you meet the requirements. You married their parent when they were under 18. right? And now they're over 21. And you want to know, can you still file for them? Yes, they still count as your stepchildren, right? Even though they're now over 21. Now, another question is, can you file for them if you have divorced their parent, right? You are no longer in a relationship with the parent, and you want to know if you can still file for the stepchild. The answer is yes, as long as, right? Yes, you can file for the stepchild as long as you have maintained a relationship with that child. All right. So that's how you can file for a stepchild. You have to meet the requirement, marry the parent before they turn 18, and then you can file for them just like you would a biological child. Even if they're over 21, even if they're married, you can still file for them. If you are now divorced from their biological parents, you can still file for them. They can still count as your stepchild as long as you can prove that you have maintained a relationship with them. So if you meet those requirements, then you can file for them just like you would your biological children, right? So let's talk about the process, right? So you are a U.S. citizen. I get into that mind frame. You are a U.S. citizen. You have a child that's in the U.S., came in with a visa to visit, and now you want them to stay. Or you came in with your child, now you became a citizen, you want to get them status. What do you do? Well, it depends on how old the child is, right? If the child is under 21 and are married, you can go ahead and file an I-130 and an I-485 for them. You can go ahead and apply for them to get their green card. And you just have to wait for the processing time for USCIS to process the application, and they can get it, right? This is for biological children and for stepchildren. Like I said, adopted children, I'm going to do a whole separate video on how that whole system works. All right. If your child is in the US and they are over 21 and are married or even married, does not matter, right? Like I said, the waiting time for a visa to be available still applies to them, right? Remember, I said that if the child is over 21, the waiting time right now is around 7 years. And then if they are married, the waiting time is around 13 to 14 years. So if you file an I-130 for the child, just know, because they're over 21 or because they're married, they still have to wait for that visa to become available. It does not matter that they're in the US, right? That's not what decides how quickly the process goes. It just is dependent on what their status is as far as your child, right? Their age and their marital status. That's what matters. So if they are over 21 or if they are married, they still have to wait for that processing time and the visa to become available, and then they can apply for adjustment of status. If right, they can apply for adjustment of status in the US if at the time that they are applying for adjustment of status, that they are in legal status in the US. So if you have a child that overstayed, and let's say you file for them, a child that's over 21, you filed for them 7 years ago, and now there's a visa available and you want to apply for adjustment of status in the US, right? The child is in the US and you want to file for them to get their green card in the US. The child must currently, as of today, be in status. So that means they either have to be, a student visa, they have to have some form of visa in the US, some form of status. If they came for a visit and they were given 6 months to stay in the US, they should not overstay that, right? If, the visa becomes available on month 4 of them being in the US, they can apply for adjustment of status in the US because they are in current status. So it's really important that you know that just because they are physically in the US doesn't mean that they can automatically apply for a green card, right? If they are not in current status, they cannot apply for a green card in the US. They would, if they have overstayed a visa, they would need a waiver and they would need to leave the US and finish the process and come back in. All right. If they are outside of the US, then it's easy, right? If they are not physically in the US, it's an easy process. They just wait it out, wait for the visa to become available, go through the embassy stage and get their visa and come in as a permanent resident. Like I said, if they at this time have children, the children can be included in the visa application, not the I-130, because the I-130 is just for the child, for your child, right? But if they, if at the time you're filing the I-130, they don't have children, but the time they're applying for the visa, they have children, they can include the children at that stage. And the children can also get a visa to the US based on the fact that you filed for your own child. All right. So that is the breakdown, right? A US citizen can file for their unmarried children. They can file for their married children. They can file for children that are under 21 and children that are over 21. They can file for adopted children, biological children, and step children. Permanent residents can file for their unmarried children. That's it. It doesn't matter if they're under 21, over 21, as long as they are not married, the permanent resident can file for them. And they can, again, file for their adopted children, their biological children, and their step children if they meet the requirements for that. So that is the breakdown. I hope this has been helpful. If you have questions or you want to know if, you meet the requirements for step parent, step child, I do have a video where I just break down the step parent, step child section of this whole guide. And if people are interested in that, I can do a follow-up video just on the step parent, step child. I will be doing a video on the adoption, because that is such a big part of this whole immigration journey for parents that want to adopt or they already went through the process of adoption in a foreign country and they want to bring the child to the US. What does that even look like, right? How do you even get them here and get them a green card? So I will be doing a whole separate video next week on filing for adopted children. So if you are interested in that, please join me next week or watch in a replay. I do like my replay people. If you have questions, please put them in the comments. I do go back and look at the comments and respond. And like I said, I know you are all busy. You want your children to get their green card. So I wanted to do like a very short, comprehensive video on filing for children, right? Now that you know the basics, let's talk about the forms, because I don't want to miss that part, right? Because you want a comprehensive guide. So let's talk about the forms that you need to file. So on the first part is an I-130. So whether the child is in the US or outside of the US, an I-130 must be filed. USCIS does not play with that. You cannot go to the embassy, you cannot go to the green card without filing an I-130 first. So you have to file the I-130, wait for that to be approved, especially if the child is outside of the US or they're over 21 or married, right? But if the child is in the US and under 21 for US citizens, then you can go ahead and file for them to get their green card, and you can file it together with the I-130. All right. If they are outside of the US You would need to wait for the I-130 to be approved, wait for them to go and have the interview at the embassy. Again, if they're over 21 or married, it is going to take longer because the visa has to be available. And then they go to their interview, get approved, come into the US, right? At that embassy stage, I know I say embassy stage. At that embassy stage, you have to do a DS-260 for your child, right? This is not, it's not asking for you. The DS-260 is not for the US citizen, it's for the person that's going to get the visa. All right? It's not for you. Do not put just your information in there, right? There's a section that they ask for the parent's information and the petitioner's information. Great, put your stuff in there. But when it's asking for name, date of birth, and all that information, have you been vaccinated? It is talking about the child that's going to get the visa. All right, so do not make that mistake because I've seen people do that. So when it's asking those information, it's not about you, it's about the child. There's a section where it asks for social media. So just because you may not have social media doesn't mean that your children don't. So make sure that you actually get that information from them and put it in there, because basically you're saying when you submit that DS-260, you're saying that everything on it is accurate and you swear to it. And if the embassy finds out that it's not accurate, that is a problem. So make sure that the information you're putting on there is accurate. All right. And then as far as documentation, like I said, for your biological children, you need to include their birth certificate, showing your name on the birth certificate, right? That's the immediate proof. If USCIS wants a DNA test, if the embassy wants a DNA test, they will ask for it, right? You do not go and do a DNA test and include it with your application, because they're not really going to accept that, because they don't have to believe you, right? When the embassy or USCIS wants a DNA test, the DNA center will send it directly to them, right? They will give you a copy, but they will send it directly to USCIS. And if your children are outside of the US, they will also coordinate with the embassy for the child to go to the embassy and get their DNA collected for the test. So do not spend the money to do the DNA test before you file, because if USCIS wants the DNA test, you'll have to do it all over again, because they have their own specific procedure on that. All right. So just gotta put it out there. For adopted children, like I said, you need proof of the adoption and that the adoption went through the right procedure. Okay. And that you meet all the requirements for it. Again, video coming next week. And then for stepchildren, right? Not only do you have to prove that you are married to their biological parent, you have to prove that you got married to their biological parent before they turned 18. So, of course, your marriage certificate and their birth certificate will prove that. If you are no longer married to their biological parent and you still want to file for them, you have to provide evidence that you still maintain a relationship with that child. Okay, so even though you're no longer married to the parent, you can still file as a step parent as long as you have maintained a relationship with the child post divorce. Okay, so those are the forms and the evidence that are required. If you have questions, like I said, go ahead, put them in the comments. If you would like to have a private time with me to talk about your specific case, feel free to schedule a strategy session by going to lilylegal.com or by calling my office at 508-443-1788. Thank you all so much for watching this video. If you found it helpful, please do like it, share it, and comment if you have any questions. All right. Thank you so much for joining me today. As always, I am Lilian Chukwurah. I am a U.S. immigration lawyer, and I help my clients get green cards and citizenships. Thank you so much.